Good morning, everybody. Welcome to this seminar, which is entitled Artificial Intelligence and Dispute Resolution. And the pedagogy I will adopt is a Socratic method. In other words, I think in Chinese we call it 八真隐喻. So I actually, after the presentation, I would welcome questions and answers, and I suspect I will learn probably far more from you than you might from me. We know that the success so far of big data in predicting outcomes in this resolution is 70%. 70% is a very significant number, because we also know that even the top legal practitioner, the top lawyer, the most expensive lawyer you can retain, whether in Hong Kong, China, New York, London, cannot enjoy that level of success in prognosis, cannot enjoy that level of success in predicting an outcome. I believe the highest success rate for human prediction of outcomes is under 60%. But for big data, is already 70%. And with the advance of big data, and we know big data is self-learning, machine self-learning, the degree of accuracy in predicting outcomes would exponentially increase. And it is foreseeable in the near future that big data could achieve an accuracy result of over 90%, which will be revolutionary. We also already know that big data analytics can predict the outcome of decisions in the US Supreme Court. It can predict the outcome of decisions in the European Court of Human Rights at a far higher level of accuracy than the top practitioner, the most experienced barrister, the most experienced advocate, and the most experienced trial lawyer, and so on. And I suspect that in China, big data can predict the outcome of decisions of, let us say, the Supreme People's Court at an even higher level of accuracy for a whole number of different reasons, which time doesn't allow me to go into this morning. But one of the, I guess, advantages we have in China is the Smart Courts initiative launched by the Supreme People's Court, which captures decision and outcomes. And with that database, I think we can predict outcomes in litigation in China. We can predict outcomes of arbitration, CTAC arbitrations, for example. We can predict outcomes of arbitrations in the Hong Kong International Arbitration Center with a very, very high degree of accuracy. Simply because arbitrations involve usually commercial disputes or investor-state disputes, and the range, the spectrum of disputes, the spectrum of facts and factors that arise in arbitration is relatively limited compared to, let us say, what arises in divorce proceedings or what arises in criminal litigation, or what arises in a whole range of civil disputes which are not amenable to arbitration. So I think for arbitration, the results would be even more astounding. Now, let's go beyond China. Let's go beyond the US, UK, and those jurisdictions. Let us look also at what we are doing in relation to capturing big data in terms of judgments of the 65 countries which constitute the Belt and Road Initiative, 一带一路. Now, there are many initiatives which attempt to capture it, I imagine at Beida, people are looking at that too. But certainly, one of the education organizations I'm involved in, is currently capturing judgments from 65 countries falling within the Belt and Road. And with that database, with that judgment database, which spans a range of different jurisdictions, obviously civil law jurisdictions like Russia, also Islamic law jurisdictions like Iran, also common law jurisdictions like Malaysia, Singapore, India, Sri Lanka, Bangladesh, also hybrid jurisdictions. In other words, hybrid meaning different strands of legal thinking and jurisprudence from different traditions, usually Islamic and common law, like in Pakistan, for example, like in certain countries in North Africa, like certain countries in the Gulf, like Abu Dhabi, like Dubai. We know that with this database, which is growing by the day, we can also predict outcomes. We can also standardize judgments. Standardized judgments meaning that we can arrive at a basic minimum of legal and judicial standards and protections so as to allow for predictability of outcomes, so as to allow for fairness in dispute resolution. The initiative I'm involved in on Belt and Road for the 65 countries actually focuses on arbitration, on ADR, which, as I've said earlier, is the low-hanging fruit. It allows for, I think, a very high level of predictability, which would inure to the benefit of people living. Obviously, in Belt and Road countries, it would inure to the benefit of companies. It would inure to the benefit of traders, investors, people dealing with the commercial life and economy of each of these 65 countries, which of course includes our own. Let me move on to look at some of the complexities, because I don't want to paint a picture that all is well, that we have started this massive revolution, and therefore we will live in paradise very soon. Life is not like that. Life is very complex. Life is full of challenges. Now, what are the challenges? What are the limits to using artificial intelligence and big data in terms of dispute resolution? I will focus on three areas to penetrate this particular mystery. The first is the question of access to the system, or the availability of dispute resolution. In other words, the first and primary question is whether a disputant, a party with a problem that he or she, or it, if it's a company, requires to be resolved, can actually enter the system. Now, whilst we've talked about technology as being the great equalizer, the great facilitator to people entering the system, it could also operate as a barrier. What do I mean by that? Why would technology operate as a barrier? I think it can definitely operate as a barrier for people coming from a low social economic background. In other words, poor people who have no access to a computer. Or put it another way, people with low levels of education. So, are they enabled? You could argue either way, but I think, to be honest and realistic, we have to accept that poor people, less educated people, people without access to equipment, to hardware, without access to a particular type of knowledge may find it difficult to access the system, simply because it appears too alien, appears too technical. What is the answer to that? Obviously, the answer is education. That is the most basic and obvious answer. We need to work at that. And I think all I want to say at this stage is, let us not be too complacent. Let us not pretend that life is very simple. Life, I think, is not. So all of you, I believe, live in Beijing. And you don't need me to tell you that many people in Beijing do not have the advantages that are enjoyed by you or enjoyed by me. And I think there's a moral duty actually to help those people access justice. It's just a simple point, and you don't even have to appeal to morality or civic duty. You can also talk in terms of practicality, because if there is no equalizing, no equal access to justice, then we do not have a stable or sustainable society. So whether you believe in morality or not, I think even if you're extremely practical, you want to help people access justice, whether it's to litigation, civil courts or the criminal courts, or to arbitration or other forms of alternative dispute resolution. Now, let me point out another complication here. Whereas technology, we've discussed, is the great equalizer. It allows people, even without a lawyer, to enter the system, because you get prompting, you get help in electronic filing, and so on and so forth. So you don't need to be a rich person to actually use the legal system if you have technology. But on the other hand, we have to recognize that technology is in many ways neutral. It could facilitate too much access to justice. What do I mean by that? Why do I say technology can facilitate too much access? Why is that a bad thing? I think the answer is very simple. If the barrier to entry, if the threshold, the menlan to entering the system is very low, then if you have a vexatious litigant or a recreational litigant, somebody who by nature, by character, by personality, is very interested in taking every single dispute to court, he or she can bombard the system because it is so easy to press a button. So with a couple of clicks, you can flood the system with cases. You can flood the system with complaints. So I think we have to be realistic. We have to recognize that technology is basically neutral. It's a great facilitator. Whether you use it wisely or you abuse the system is up to individual human nature. Now, human beings, we know, are flawed. Human beings are not saints. Human beings have their problems. They have their imperfections. And if you like, some people are more imperfect than others. Some people are more vexatious. Some people are more disputatious. Some people just like to argue. Some people just like to fight. Some people just like to make trouble. Some people just like to make life impossible for people they dislike. Now, we've seen that with the internet, right? The internet, social media, we know can be abused, right? Social media, if you like, is a great equalizer. It allows somebody with hitherto no voice, who is not a newspaper editor, who is not a radio talk show host, who is not a big pop star, who is not a big movie star. It allows the small person to have a voice. But we also know that social media can be abused. We also know that people can use it to spread false news, fake news, rumors. And in the same way, people with, let's say, sociopathic or negative antisocial tendencies could abuse the system by flooding it with vexatious complaints and start 100 cases a day if they want, right? So I think the answer is we need to devise safeguards. We need to devise safeguards so as to protect what we call the public commons, to protect the system from such abuse. And the abuse comes from imperfections, limitations in human nature. Let me move on to the next point. I've talked a little bit about the power of big data in predicting outcomes of dispute in litigation, in arbitration, and so on. And that's a very powerful tool. But are there limits to this? The answer is, at the moment, there definitely are. What are the limits? Obviously, if you feed certain facts, circumstances, evidence into a computer, into a massive database to predict the outcome of those sets of facts, those paradigms, and say how would a court look at this, and what is the likely outcome, you will get a certain result, right? Which could be very helpful to disputants and litigants, because it could save them a lot of money if they say, well, with these set of facts, my chances of success are only 30%, or my chances of success are 25%. Maybe I should settle. Maybe I should not waste money on a lawyer or waste my time and energy in fighting this case. I should resolve this. That's a very positive thing. But there are certain matters on which, at the moment, big data is not good at evaluating. What are those factors? I'm looking at subjective and social facts. What do I mean by that? When you look at hard facts, whether you owe somebody money on a rental agreement or on a contract of sale of goods or hire purchase, that's easy. But when you have to assess as a tribunal the credibility of a witness, it is not so good. Big data and AI is not that sophisticated because when witnesses give evidence, whether in arbitration or in litigation, whether in a civil case or a criminal case, you have to look at their behavior, their demeanor, their facial expressions, how they conduct themselves when they're in the witness stand. At the moment, big data is not that good. Now, it doesn't mean they will not get better, and I'm sure big data will improve and AI will improve because AI is machine self-learning. So I'm sure they will get better, but we're not there yet. So I think we need to be sensible and wise enough to recognize that there are limits to big data, because I think we have to recognize that up to now, we can't just say, well, if I have a problem and I need to go to arbitration, if I have a problem, I need to go to litigation, all I need to do is to let the computer decide the outcome for me. I don't think we're there yet. And I don't think if you appeal from a decision that you're dissatisfied with, you would say, well, now I go before 3 computers. Let the 3 computers decide on a majority vote, 2-1, what the answer is. I don't think people will accept that. We're not there yet. So I think we need to have a bit of common sense. We need to understand that so far, we also need human input. The third matter I want to look at is a question of procedural protection. And I also want to look at a related question about algorithmic bias. What do I mean by that? Why are algorithms biased? Why is there even the possibility of bias on data? The answer is really this. Because machines self-learn, they gather information which are historical. In other words, they learn from what has happened in the past in order to, in our case, predict what might happen in the future. But if the past reveals that certain sectors or segments or groups or classes in society have, because of structural disadvantages, behaved in a certain way, does it then mean, because we apply big data analytics, that we will then predict that this group is more likely to behave in a criminal way, more likely to breach a contract, more likely to commit a burglary, more likely to commit murder, more likely to commit rape, and so on and so forth? These are very, very important questions. And we know already that in the United States, the research has revealed that algorithms are capable of bias. In this sense, that because they predict outcomes and they predict not just behavior, but also predict how courts would deal with these situations. And because in the past, for all sorts of socioeconomic and other reasons, African Americans, American blacks, who are proportionately incarcerated, put in jail, a lot more than whites. And statistically, they are convicted of far more criminal offenses than whites. Then when machines use big data to learn, they will exacerbate, complicate, and add on to that bias. So there's a very famous AI risk assessment tool called COMPAS, COMPAS, which looked into this and revealed that bias. So again, because of time constraints, I'm not going to take up time this morning by going to the details of that, but I think we need to recognize that there are certain limitations, even on relying on big data, because big data cannot be treated as if it is the absolute truth because of inherent biases. Let me move on to another limitation, which is this. We have said at the beginning of this talk that technology can equalize. It can help the small disadvantaged person, even the one who cannot afford a lawyer, to access the system and to seek justice and to get the right outcome for him or her. But we also know that even with technology, there are power imbalances. And sometimes these power imbalances are increased, exacerbated by technology. What do I mean by that? I mean that when parties with greater financial resources have access to a dispute resolution system using technology, they are also able to accumulate asymmetric experience and information. What do I mean by asymmetric experience and information? What I mean is, the more you use a system, the more you repeat doing a certain thing, the better you are at it. We all know that because all of us exercise, I imagine, right? And the more you exercise, the easier it gets and becomes natural. And if you lift weights, you get muscles. If you do sit-ups, you get six packs, you get your abs, and so on and so forth, right? So the more you do, the easier it is. Now, technology being neutral in that sense, a very powerful player like a multinational company or a very rich man or woman or a very powerful institution would have far greater accumulating experience in using that technology to access the system, as opposed to a person who has maybe once in his or her lifetime a serious problem that he or she needs to resolve in order to survive, to recover some money, or to seek some justice. And there you get the asymmetric experience in information. And how do we counteract that? I think we do need to treat this very seriously. And again, we need to redress that imbalance. And so in many different ways, we need human interaction. So that's the good news for lawyers, for people, like all of us. We are not redundant, definitely not yet, because there are many things that machines and big data and AI can do, but not everything. And ultimately, you need safeguards. You can't just say, well, I just leave it to my computer and everybody trusts the computer to get the right outcome. Don't like it, go to 3 computers. Don't like it, go to 5 computers. Life doesn't work like that. And people won't accept a system like that. So ultimately, the human element is very important. And ultimately, we need to go back to a deep philosophical question, which this pandemic has allowed us to focus on, which is what is really important about a system and what is really important about dispute resolution. My answer is access to justice and delivery of justice. That must be the ultimate answer. And we know that justice doesn't arise from a room where 1 judge or 3 judges or 5 judges sit and decide. Access actually comes from a whole combination of factors. And I think we can, if we approach this matter sensibly and wisely, arrive at a much higher quality of justice delivery using artificial intelligence and using big data. So that's my presentation today. I'm very happy to take questions and we can exchange points of view. So anybody has any questions? Please feel free.
Hello, Professor. I have a question.
Yes, please go ahead.
My name is Willie. You mentioned that the use of big data may bring too much access to the justice, and you explain that it's because it will be too easy to file a lawsuit, just like press a button, and this will bombard the system. But I think the use of big data may also help to simplify the procedure of dispute resolution, and maybe it will be very easy to resolve a dispute in the future, and maybe the dispute may be resolved automatically in the future. So I guess the amount or the large quantity of the dispute may not become a problem in the future because the dispute may be resolved very easy through the use of big data. That's my question.
Thank you very much, Willie. I think you raise a very important point. And I think the experience that at least we found in the UK, United Kingdom, is that it's been very helpful. We know that more than 80% of cases are now resolved in virtual courts. The number certainly surprised me and surprised many specialists. None of us expected that number to be so large in such a short period of time. And I think on balance, you're right. Big data allows for simplification, quick results, in order to get an outcome which puts an end to the dispute. So speed is very important. We know that in the past, before big data, before AI, before computers, before the rise of electronics, everything was done on paper. And we know that you have backlog of cases because courts and judges, are human, and they can be very slow. It can be very bureaucratic. And we know of one case, which a true case where in India, which I suppose is notorious in terms of litigation explosion, because there's a lot of litigation in India. There was one case which lasted more than 100 years, unresolved. The litigants have all died. Their estates obviously remain. The case is still unresolved. It is a notorious and grotesque case. This is the sort of thing that nobody wants to see, because it gives justice a very bad name. In fact, it destroys the reputation of the Indian courts. But it's a true case. We know as a matter of fact that more than 4 billion people, in other words, about 60% of the world's population, 4 billion people, have no access to the courts at all. We know that the terrible backlog of cases, which arises from no electronic transformation of the justice system, is worst in Brazil, not even in India. Brazil exceeds India in terms of dysfunction of its system. So really, I agree with you. I think big data can solve many of these problems. All we need to do is to bear in mind that there are also disadvantages which we need to address. Thank you.
Hello, Professor.
Yes.
Yes, I'm Eric.
Hi, Eric.
Yes, I have a question about the future development of the lawyers. Because as you mentioned, if we can use the artificial intelligence or use the big data to replace the roles of the lawyers, so do we need to learn some knowledge about this technology or this artificial intelligence in the future? Because I have read some news about the knowledge reformation of the new lawyers. They need to learn something about the computer science and something about the intellectual property or something about the new technology. So do you think this knowledge reformation is necessary or not?
Eric, I think you asked a very good question. Thank you for raising this point. And I can tell you, you probably know this already, that at Stanford Law School, one of the top law schools in the world, every law student is required to do coding. In other words, it is not enough that you go to law school and you learn some cases, or you participate in moot court exercises, or you write exams, or you're very good at answering questions. That is not good enough. In fact, every student at Stanford Law School has to be a technology expert, and not just superficially understand technology. They actually have to undergo coding. And this is the most exciting, to me, educationally, the most exciting development in legal education that I've seen. I'm sure maybe you can tell me more about what's happening in our country. I'm sure there's certain institutes in China which are always experimenting with this. I don't know how advanced Beida is in this respect, but I would have thought that this is a field that is absolutely essential for law students to go into. So thank you for raising that.
In Peking University, we need all the undergraduates need to take some lessons about the coding, but it is not so difficult. So I think the importance of these lessons is just to help us to know some basic concepts of the coding, but we cannot use the coding to practicing law. So I think maybe the curriculum is different in Peking University.
Yes, I think that's also a very important point. I mean, how do we treat technology? And it's a very interesting and deep philosophical question. Do we treat technology merely as a tool in order to facilitate the work that we do? So, for example, do we use technology by way of a search for case precedent so that we don't have to, as it were, do very painful research in the day when I was a law student, when obviously there were no computers, and we just had to search the different law reports or go to textbooks, go to encyclopedias, and get the right answer, hopefully. I mean, today you press a button and immediately you get 50 cases or 75 cases coming out which are relevant to the point or the specific question you answer. So it's much faster and much less painful, and definitely much more accurate. Is that the only approach to technology, or do we actually go beyond that? Do we look at technology as an inherent part of our life? So it's not just something we use, but something which is embedded in our system. Now, this is the question that the person I referred to, Richard Susskind, Professor Richard Susskind, addresses. He actually wrote a book called The End of Lawyers, ? Right? Which is quite famous. So Susskind is Susskind, Richard Susskind, Professor of Technology and Law at Oxford, and also the Chief Technology Advisor to the Lord Chief Justice of England. He actually answers some of those questions. And his answer is very interesting simply because he is not a practicing lawyer. And that's very helpful. Now, of course, he encounters a lot of hostility because many practicing lawyers or law professors don't like what he's saying, because he's questioning the very basis of their existence or their justification for existence. So, of course, they're very hostile and they're quite cynical or skeptical as to what he's saying. But I think he asked an important question. Is technology just a tool, or is it to be envisaged within maybe half a generation? People, highly educated people, will look at technology differently as part and parcel of what we do. So we know that in England, for example, in just a dispute resolution, there may be very little input, human input, into outcomes of cases in the vast majority of cases. Because simple cases like a debt, unpaid rent, trespass, those cases can be resolved quite simply, or traffic accidents. You don't actually need a magistrate to sit and listen to evidence, have a lawyer argue it. You don't necessarily need to do that. And we also know that 50 years ago, in the 1960s, in Sweden, they experimented with no-fault insurance. What do I mean by that? In traffic accidents, when insurance company pays up, there has to be usually some either admission or a court decision, like a conviction for careless driving, or some decision by the court before the insurance company would pay out. So in other words, they have to look at fault. And if you're at fault, of course, they don't pay up. If you're not at fault, they pay up. That was the approach in England, an Anglo-Saxon jurisdiction. But in Sweden, they looked at the matters quite differently, even back in the 60s. They said this is an inefficient way to address this question. You spend a lot of money on judges, on lawyers, clerks, have a courtroom. All this takes money. You need to build the courthouse. You need to maintain it. You need to pay staff. But instead of spending that money, why don't we just pay? If there's an accident and it's not criminal, then it's a civil matter for which the innocent party ought to be covered. So they of course, those were the days before big data and before electronification of the system, but it's an illustration of how we can think about questions differently from before. So again, because of time constraints, I don't think we can go into this question more deeply than this now, but thank you, Eric, for raising that point. Yeah, please go ahead.
So this is Vivian. I would like to ask a question, but before that, I would like to echo what we have learned today about access to justice, especially the availability of the clients to enter the online system. Because I remember like during COVID-19, like the coronavirus pandemic, I have read some news about the current accessibility of technology. So there, for a lot of people, for us, it may be very convenient to get connected to a computer, but actually to the access to technology is not that much, because so far, even as we are taking online courses, a lot of people are taking that from their phones or their other devices, which is not that convenient to get connected. So I would just like to echo that by comparing the dispute resolution to education, online education.
Yeah.
And so the question that was just an echo, and I would like to ask a question about how big data could predict the outcome of a case, and would there be a difference between predicting the outcome of litigation and arbitration? That's the first question, because we know that in arbitration, confidentiality and privacy has been emphasized, and which means that the cases, like the previous cases, would probably not be disclosed to the public. And how could a machine, or how could big data access that data if the clients did not agree to disclose that? That's the first question. And the second question is, would there be a difference in prediction of outcome of in civil law and in common law? Because we know that in common law, the outcomes, judges make their decisions based on precedents, and in civil law that's not the case. And would there be a difference in that as well? So that's my current question.
Yeah, thank you very much, Vivian. I think you raised two very interesting questions, and let me start with the arbitration question first. I think I've already said, I mean, this is my point of view. I'm sure there may be argument as to whether that's 100% accurate, but I actually think that the parameters of dispute in arbitration is relatively narrow compared to the parameters of dispute, let us say, generally in criminal law, in civil law, which of course, in our definition covers divorce, family matters, custody of children, etc., etc. Those are much more, I think, complex questions, because they're not easily reduced to a mathematical formula. Now, commercial disputes are also not mathematical formula, but relatively simple, because we all understand contracts, we all understand breach of contract, we all understand trust, breach of trust, and so on, right? So relatively narrower and therefore more amenable to organization along big data lines. Now, you raised the point that obviously in arbitration, you're not bound by what another arbitral tribunal has decided, because the results are not published. However, we also know that in arbitration, obviously the arbitrators use common sense, they use their experience, their knowledge, their specialist knowledge to decide the matter, whether it's an engineering dispute, architectural dispute, trade dispute, and so on. But they also look at cases. They may not regard those cases, that is, I'm talking about cases decided in court, reported cases. They will not regard those cases as binding, but in appropriate cases, they would regard them as persuasive. So that informs their approach. Now, of course, you may say, well, not every arbitrator is a lawyer, and that is, of course, true. And that's a good thing. You have a healthy mix, hopefully, not just of three lawyers sitting to decide a matter, but maybe in appropriate case, an engineer, a surveyor, a lawyer, and so on. But the likelihood is that even if you deal with a non-lawyer in, let's say, an engineering field, they would be cognizant or they would be familiar with relevant cases in engineering and so on, which they might use. So your second question goes to, I think, the difference between the approach of the civil law and the common law in dispute resolution. And I obviously, everybody accepts that the common law is built on the doctrine of case precedent, and the civil law is based on the question of codification. But we have seen in the last 50 years, 2 generations, since at least the 60s, that the civil law systems have moved much, much closer to common law systems and vice versa. What do I mean by that? I mean, first of all, we know that a civil code cannot, as it were, predict or cater to every circumstance. Civil code is like a skeleton, a structure, which guides you. But it doesn't drill down into the details. And even in civil law systems, we have seen over the past 2 generations a development of case reporting. So in Germany, in France, they cite cases too. Those cases are not binding in the common law sense, but they're highly persuasive. If you look at these supranational court systems, like the European Court in Luxembourg, or the European Court of Human Rights at Strasbourg, they also cite cases. No one would pretend that these are common law courts. They are not. They are multinational, multi-traditional systems all coming together. But they look at cases. And as I say, they would not necessarily regard those earlier decisions as binding, but they certainly would regard them with respect, and they would find them persuasive. And as a corollary to that, I would say that common law systems have also moved closer to civilian systems. Now, what do I mean by that? 300 years ago, the common law comprised case decisions, which are collected in reports called, King's Bench Division or whatever, exchequer cases and so on and so forth. And there was relatively few legislation. But today, in every common law jurisdiction, we are overwhelmed by legislation. And some would say that's a bad thing, but it's a phenomenon known as the growth of the bureaucratic state. So legislation accumulates. There's a very famous observation by one of the greatest statesmen of the 19th century in Europe, Bismarck, Otto von Bismarck, the first Chancellor of United Germany in 1871. When the more than 100 German states became Germany in 1871, they had to establish a parliament, the Reichstag, and they had to legislate. And Bismarck was not a lawyer. Bismarck thought, well, you get this parliament together for the first time, 1871, you pass all the necessary laws, and you don't need them anymore. So his idea of legislation, we just legislate and we go home. You can disband them. Then everything will take care of themselves. But real life is not like that. Real life, for good or for ill, means that legislation is a continuous effort. And why is that? The answer is because society is not, captured or stuck in amber. Society evolves, right? Everything is evolving. Nothing is static. Nothing is constant. And therefore, for good or for ill, legislation has grown. And common law systems have, in some ways, even more legislation than civilian systems. So I think at the end of the day, in the search for justice, both common law systems and civil law systems arrive at quite a similar common ground. And both systems rely on case precedents. And doctrinally, civilian systems would say, well, they're not absolutely binding, but we treat them with respect and we regard them persuasive. And in common law systems, very often the doctrine of distinguishing cases means that you would say, well, they're not binding because the facts are not identical, but they're highly persuasive and they guide us as to how we should make our decision in the instant case. So thank you very much. I think that I've overrun my time, Professor Gao, and I hope you will forgive me. We started a little bit late, but I've enjoyed this session very much, and I thank everybody for participating. And I would like to thank all the questioners for raising very pertinent questions. And as I've said, I've learned a lot from you. I hope you've learned something from me. And best of luck with the rest of your course. And I'll be very happy to continue to support the Beida program. Thank you.